Let's give folks a few moments to join, and then we will get started with the hot topics of today. Everything from the great news about the H-4 EAD to the December Visa Bulletin to some questions that we've been receiving in our Telegram group. So I hope you all are doing well. For those who are joining us for the very first time, welcome. For those who have been joining us every week, thank you for your support. We really appreciate it. And for all the folks on YouTube, welcome to you as well. So this week, great news last week after our webinar that the H-4 L2 E2D EAD litigation update has finally had some successful outcome. The USCIS issued policy guidance on dependent spouse EADs. Remember, this was brought about because AILA and other litigation partners brought a lawsuit against the USCIS and reached a settlement agreement. Shortly after the engagement was reached, USCIS issued new policy guidelines effective immediately to address the automatic authorization extensions for certain H-4, E, and L dependent spouses, rescinding the 2002 INS memo. The document combination to include for proof of continued work authorization an unexpired I-94 card or form I797C, which is a receipt notice showing a timely filing of an EAD renewal application, and a facially expired EAD may be acceptable evidence for I-9 purposes. USCIS also clarified that E and L dependent spouses will have employment incident to their status. This is fantastic because otherwise, remember, after the spouse enters on an L or an E, they would then apply for work authorization. If it's incident to status, they no longer have to apply for work authorization, which is great. The USCIS will continue to issue E and L dependent EADs upon filing the I765. EADs are acceptable as List A documents for employment and identity. DHS will modify I-94 forms I-94 evidencing that E and L dependents to distinguish spouses from children. Only once the changes are made, that means the I-9 forms in the form and the I-94 revision, form I-94 will be acceptable as a List C document, and evidence of employment authorization must have a notation indicating the individual is on an E or L dependent spouse. Automatic extensions for EL dependent spouses, if they're properly filed, file an application to renew their EAD before the expiration, and they have an unexpired I-94 card showing their status. Now that, you're probably wondering how does that play out? Because usually the I-94 and the EAD expire right around the same time. Well, what you would do is if you file your H-4 with your H extension under premium and you get that approved, then prior to the expiration of status and prior to the expiration of your EAD, then you can file for the EAD and leverage the automatic extension. The automatic extension will continue until the earlier of the end date on Form I-94 showing valid status, the approval or denial of the EAD application, or 180 days from the expiration of the previous EAD. The evidence acceptable for I-9 purposes are Form I-94, indicating an unexpired non-immigrant status, Form I-796 for timely filed EAD renewal stating what class is requested. Remember, there are different types of applications that allow for EADs, so you have to specify which type. And then, like I said, specific type. And E and L dependent spouses are employment authorized incident to status, so they no longer have to file the I-765, but they may continue to file if they choose to receive an EAD. So you can file it. What we'll have to wait for is the changes in the I-9 regs, because right now it's not listed as a List C document. And so even though the regulations are in place for allowing for the authorization, employers still need to be directed as to what are acceptable documents. If your E or L EAD extension is still pending, can I start working again? Until the INS is able to issue, as I said, I-9 regulations, we have to wait on that before you can really leverage the benefit of these changes. My H-4 EAD extension is pending. Can I begin working again? If the spouse filed an I-539 to extend the H-4 status, the H-4 spouse will not qualify for the auto extension grant until the underlying status is granted. That's why I said, for strategy purposes, the best thing to do is you can file an extension 6 months in advance of your expiration. That's the best time to do it. So if you go ahead and file 6 months in advance of the expiration under premium processing, then you can leverage the automatic extension. And by the time the EAD will be issued, it should be well before the 180 days after the expiration of the previous EAD. December Visa Bulletin, EB5 for mainland China is current. That's going to be very exciting for a lot of people. And that is a direct indication of how fast things are being processed. Because remember, the regional EB5 applications are being held in abeyance. So this is not only good news for mainland China, but for all applicants, it is an indication of what, I'm sorry, I've got to take this off, I'm hot, of what I've been saying, which is you're going to see faster processing of EB5 direct applications. And there's a lot of people that have been contacting us to get information on this, especially if you're stuck in the backlogs and you're not really confident, as I am not, that Congress is really going to act on anything relating to this anytime soon. First time, the Regional Center program has not been reauthorized yet. Remember, that's the Regional Center. Direct EB5 investment is not subject to renewal, only the Regional Center. So they note that when the Regional Center is reauthorized, we predict a couple of things may happen, that the threshold may increase of your overall investment, and there'll be more of a demand for EB5. And so you want to get in now while the EB5 regional centers are held in abeyance, so you can be processed a lot faster under direct, because the USCIS, as we reported last time, sees a substantially lower number of direct investments versus regional center. As of November 1st, there were 49,000 EB5 applicants, including investors and derivatives, waiting at the NVC, with 86% of them from mainland China. India and Taiwan saw the largest increase in applications, showing a growth of 134% and 146% respectively between 2020 and 2021. Approximately 19,880 visas are available to EB5 applicants in fiscal year 2022. So the Regional Center reauthorization, if and when issued, should significantly reduce the backlogs. According to Charlie Oppenheim of DOS, a total of 280,000 immigrant visas are available for employment-based categories in fiscal year 2022, another record high given the unused family-based visas in 2021. USCIS has not announced yet which chart will be used, but the final action date shifts are EB1 remains current for all chargeable areas. EB2 progressed from December 1st, 2011 to May 1st, 2012. That's pretty substantial. EB3 for India and China remain the same as was predicted. Dates for filing chart shifts. EB2 India progressed from January 8th, 2013 to July 8th, 2013. EB3 for India and China remain at the same January 22nd, 2012 and April 1st, 2018, respectively. Some of the questions that we've received from our Telegram group, and I want to tell you, we will take questions at the end. Please post your questions in the Q&A, but we have many ways in which you can connect with us. We've got, of course, our weekly webinars. So it would be great if you find these useful, if you can share our links with your friends. We have a lot of really good information on our YouTube channel. So if you subscribe to the channel, you'll be alerted anytime we upload the channel with a new document, with a new video. And then there's our Telegram group. This is a group that a community of people who are going through the same immigration process as you are. Very helpful, very insightful. And what's nice is, as opposed to different all other forums, this forum is something we moderate, and we make sure that any disinformation that may be shared is quickly corrected with the correct information. So please join us on the Telegram group. And the reason why I say that is here's some questions that we got from our Telegram group. Interfiling from EB3 to EB2 after an employer change. If the EB2 and EB3 are based on the same term, is interfiling possible? Yes, but remember, when you interfile, that triggers, for AC-21 purposes, the 180 days all over again. So remember, for AC-21, you have to have an approved I-140, adjustment has to be pending for 180 days, and it has to be in same or similar employment. So when you interfile, because you're touching the adjustment again, really, with a new classification, the 180 days gets re-triggered. When do you file the I-45J? I know a lot of people say that their employers tell them to file it after they get an RFE. I wouldn't do that. If you look at the delays that an RFE causes, I would be proactive. And as soon as you change employers, I would send that in, maybe wait for 1 or 2 pay periods. So then you can send that in, you can send your pay stubs in, and hopefully avert an RFE. When you decide to change employers after 180 days and the I-45 is pending and an approved I-140, okay, yes, as I said, you can file with the new employer. And our clients have filed the interfiling request after the I-45J, given their employment timelines and the movement of the Visa Bulletin. It should be also possible to file the I-45J and the interfiling request at the same time, which is what we have advised a number of folks. When can I change employers after an interfiling request? Like I said, the 180 days. So I hope this question answers all the questions for our Telegram group folks. And Lainey, if you will join me now. Lainey is taking the place of Shekhar Challa, who is away, and she will be moderating the Q&A. Thank you, Lainey.
Sure thing. Okay, we have a couple of questions. First, my spouse is on a change of status, F1 to H-1B. She's visiting India for the visa stamping. She filed the I-485 recently in October 2021, but there's no advanced parole or EAD. Does traveling to India without advanced parole cause her I-485 to be abandoned?
No, that's a very good question. H-1Bs and Ls have what's called dual intent. So you can intend to reside in the US temporarily, and you can intend to reside in the US permanently. The great thing about that is that means you can either travel on your AP or you can travel on your H or L visa. For all other classifications, you have to wait until advanced parole is issued. Otherwise, the underlying adjustment is deemed abandoned. But that is not the case for H's and L's. So for H has already been approved, if it has been approved, because remember, If you travel pursuant to a change of status from F1 to H1B prior to the approval, that will also be deemed an abandonment of that underlying change of status application. So premium it if it's not approved yet, so you can get it expedited. Once it's approved, she will be able to travel and get an H-1B stamp if she needs to return, he or she.
And as a follow-up question to that is, they want to know if there's a time limit on how long they can be in India without risking that I-45 abandonment.
No, I mean, I think, there are challenges when it's approved when you're away, when you're entering the port of entry, not major challenges, but that's the one thing I would be concerned about. But there is no, as long as you continue to intend to reside here permanently, there's no specific time frame as to how long you need to be out. You can be outside the United States. As long as, like I said, the person is not on an F status and they've actually changed status to the H, because the F doesn't have dual intent, but the H-1B does.
Okay, we have a question from YouTube. Would USCIS process a second I-485 without any hassle? Some forums say that it is complicated. Can you please shed some light on that?
No, the regulations, and we had a webinar, I think last October, just on this issue, and I cited to the regulatory guidelines. So take a look at that, and so you can see for yourself. The regulations state the USCIS will only approve you as a permanent resident for one I-485. Does not preclude the ability to file multiple 485s. At just some point, they'll say, which one do you want to use to adjust? And you pick, that's it, and withdraw the other.
Can immigration medicals be paid by HSA or the health savings account? Is there any issues from the IRS?
No.
Then we have questions from Telegram and YouTube. It's the same question. That an H-4 is not being approved along with an H-1 under premium. And then the one on YouTube, the same idea. Is H-4 approved along with H-1 under premium processing? I did the same, but only H-1 is approved. Can you please clarify?
Right, and it could be for a couple of reasons. They should be using the previously issued biometrics if there was a previously issued biometrics. And if you don't have an EAD accompanying the H-4, then they would adjudicate them concurrently. If not, what they're going to do is, there's a biometrics that have to be done, then the H-4 gets approved, and then the I-765 EAD gets approved. So it depends on all those factors. And I think we have a memo on this that I think we will share, or a YouTube video where we talked about the change on the biometrics. Oh, there it goes. Biometrics not required for H-4s anymore. So they went from using the previously used biometrics, and that's what I thought. They changed it. Thank you, Kara, for the clarification. They changed it so biometrics are not used. So did you file an I-765 with your H-4? If once they respond, I can follow up on that, because that may be the reason why the H-4 wasn't adjudicated, if they filed an I-765 with the H-4 extension.
Okay, we can wait on that response and move on to the next question. Also from YouTube, do you see EB3 progressing to December 2012 by October of 2022?
I think what we will see is, because remember, it's January 2012, and I think Oppenheim last month said he doesn't think, and I don't think that we'll see much of a move until mid-2020. So before that, remember, it would just move very incrementally every month. It wouldn't move by months. Sometimes it would be days. Sometimes when we were happy, it would be a week. So I think we're going to, unless there's some change, we're going to see that type of movement, but we'll have to wait and see.
Next question is, I had come to the US on an F1 visa for a master's. When I was pursuing my master's, I had a problem with my school and my status was terminated. I was out of status for 6 months, then I applied to a different school as a new F1 student. I went to Mexico for reactivating my new status and came back to the US. I had completed my master's in 2019, got my OPT, and also my H-1B was approved the first time I filed. My H-1B was approved on October 2020. Now I'm planning for an H-1B visa stamping in India on December 27th, 2021 in New Delhi. My only concern is, will the visa officer come to know about the illegal stay in the US for 6 months? And is it safe to go for a visa stamping in India?
Yeah, they may question that. The good thing is F1s don't accrue unlawful presence, so you're not subject to the bar unless there is a judge renders a decision or there is a denial. And when you make a re-entry, it kind of cleanses any previous violations of status. So I think the likelihood that they will raise that is very low, and the risk threshold should not be high for those two reasons.
Is it possible to port an EB3 priority date to EB2 filing with a new employer?
Right. So when you have an approved I-140, that priority date vests with you once it's approved. So when you go, you'll have to go through the process again with a new employer. But yes, you'll be able to leverage that priority date.
Just to clarify on an earlier topic, approved I-140 from employer A, both EB2 and EB3 separately, 180 days have passed, remain valid for interfiling by employer B along with an I-45J. Employer B does not need to start the green card process all over again, correct?
Correct. Now, as long as the I-140, because I'm trying to make sure, just for clarification, the I-140, when you interfile, has to be based on the same perm. So if you've got a perm from two different employers, one EB2 and one EB3, you can't interfile. But if the EB2 and EB3 are associated with the same perm, you can interfile.
The next question is back from YouTube. Does USCIS still have no blank spaces in Form I-131 and I-765?
What was it that again? Does the US blank spaces? Policy is eliminated. There you go. Kara, last set out our memo on that. And for those of you who—
Kara's fantastic.
Yeah, previously it was the most insane thing. The USCIS said if you leave any questions blank, because typically you'd have to put NA, if you leave anything blank, then you had to fill out every single form that was applicable, I mean, every single question that was applicable, or put NA or none, which was a bizarre policy. I mean, we do that anyway. I do that, as a matter of practice, but it was because especially on those forms, the I-131, I-765, it'll say if X doesn't apply to you, go to question, so you skip a bunch of questions. So then you'd have to go back and say NA, even though the form tells you to skip those questions. So blank question policy has been eliminated, so you don't have to worry about that.
Can we interfile back to EB2 if our filing date is current in the new bulletin? My downgrade is approved.
Yes. As long as you filed a new, when you downgraded, as long as you filed it as a new petition and not an amended.
Are they accepting filing dates for December Visa Bulletin?
They haven't stated yet. We just know we're still waiting on the USCIS to state whether they're going to accept dates for filing or final action dates. So we'll have to wait and see. Join our Telegram group and we'll let you know as soon as we know.
Going back and regarding the person whose H-4 hasn't been approved, he confirms that he's our current client and we did file an I-765 with it. Okay.
And so if an I-765 was filed with it, because remember, this new rule just came out last week, then they're going to continue to adjudicate them. And that's probably why you didn't get the H-4 adjudicated along with the H-1B.
Another question from YouTube. My prior employer who filed my EB2 green card, the priority date is May 2012, is showing negative taxes every year. Can I go back and file I-485 with him? Is there any chance of an RFE on that 485? Right, because remember with the previous employer, there are 3 ways to show ability to pay. Anytime you file, whether you're doing a downgrade or whether you're filing a new I-140, one of the things the employer has to demonstrate is ability to pay from the time the perm was filed. And they say until the green card, but effectively it's until the I-140 is filed. You can do that either by showing that the proffered wage on the perm is equivalent to the net income of the employer's tax returns. Then you can show that the net current assets are greater than the proffered wage. You can show ability to pay by saying that the employee has been paid those wages. The challenge comes to when you're using a previous employer, you're no longer being paid by that employer. So you can't use the third prong. You can only use it for the period of time you were paid by the employer. But you can use a combination. The net income is not high. Sometimes if you look on the balance sheet, the net current assets may exceed the proffered wage. But unless you're able to meet one of the 3, your I-140 will definitely get denied. That is all of our questions up to now. If you have any more questions, you can go ahead and put them in the Q&A box or on YouTube. We can give it a second, but I think we're good. Up to date. If you have any additional questions after we finish this webinar, email us at info@shalalaw.com. And I want to thank, as always, my team for helping put this together. They are amazing. And thank you, Lainey, for stepping in for Shaker, who is on travel today, and Kara for all the amazing links. I don't even think I get the answer out and the link is up. You get that up really fast. And as I said, please share our webinar with your friends so we can get more people well informed so they can, have control of their immigration journey. And next week, because it's Thanksgiving, we'll be taking off. But the week after, make sure you join us. We're talking about visa processing in Mexico and any additional immigration updates. So I hope to see you then. Thank you again, Lainey. Thank you, Kara. And thank you all for joining us.